AI is evolving rapidly. What are the key contract provisions you need to be aware of? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney for over 20 years. I've drafted and negotiated a variety of technology related contracts and litigated failed technology projects in courts across the country. One of the biggest issues in any AI contract is going to be around data ownership. In today's environment, most vendors are not going to try to get an ownership interest in your data. They're going to concede that your data is your data and that you should retain ownership of it. But I think with respect to artificial intelligence in particular, it's really going to be about how to control that data. The vendor is going to want to have as broad of access to your data in that system to be able to do what it wants to with that data. And I think it's important for you to put some fences around the scope of what that vendor can do with your data. The vendor is going to want to train their AI model on the inputs that you're putting into that AI tool. They're going to want to define to some extent what you're able to do with the outputs. And then they certainly want to control your ability to access and use the data. One of the biggest issues in any AI contract is going to be data ownership and the scope of what the AI vendor can do with that data. I think it's relatively settled these days that the customer is going to have and maintain an ownership interest in the customer data. And I don't think it's reasonable for an AI vendor to try to contractually give itself an ownership stake in that data. But what they will try to do is have as broad a scope to that data as they possibly can. They're going to want to be able to use that data to train the AI functionality on. And that may be something that you want to give them the right to do, or it may not be something that you want them to have the ability to do. And there's a variety of nuanced considerations associated with that. I mean, who has access to the data that you put into that system? Do your competitors have access to it? Is it going to be treated confidentially? Are you giving up any kind of trade secret ownership interest in data that you put into that AI tool? So the issue of data ownership, giving up inadvertently ownership of any intellectual property rights associated with the data becomes important. The right to control that data becomes important. And without a doubt, I mean, you're going to want to define how that vendor can use your data, what it can do with it, and what steps it is going to take to protect that data. The next substantive issue that we will deal with in AI contracts really has to do with intellectual property. And the issues associated with IP are going to be around the ownership of the AI functionality or the IP associated with that AI functionality. You want to make sure that the vendor owns it or has rights to it. You want to have an understanding is this actually, original AI functionality that vendor has developed? Are there third-party plugins? Is it just an interface to something else? I mean, are you paying to interface with ChatGPT? If so, what's the value associated with that? But the ownership structure of that AI tool is incredibly important. And you need to clarify that within the contractual framework that you've got with that AI vendor. You want to make sure that that AI vendor has an ownership interest or the right to give you the license to use associated third-party technology. So maybe there are other add-ons or plugins that you need to be able to use in order to utilize that AI tool. You want to make sure that the AI vendor has the ability to give you the license rights that it is giving in that AI contract. You want to clarify which or who owns the associated inputs and outputs. There's certainly going to be intellectual property issues associated with whether, the inputs are protectable from an intellectual property standpoint. And I think, to the extent they've got original creativity associated with them that would qualify for copyright protection, there's certainly, they're going to be protectable. But really beyond that, what happens to the inputs once they're in that AI tool? You want to have an understanding of who owns the outputs from an IP standpoint, or even from a proprietary standpoint. Is the vendor going to claim an interest in the outputs that are generated by that tool? or are you free to use them? And if you are, what's the scope of your use rights associated with the outputs? So, all of these need to be clarified in the contract with a high degree of specificity. Warranties are incredibly important in any contract, and doubly so in an AI contract. The contract needs to state who is on the hook if the AI tool underperforms, if the AI tool makes biased decisions. You want to be able to hold that vendor to task if the AI tool fails in any kind of critical way. You might be using that in connection with medical imaging. You might be using it in connection with making critical decisions. And if it doesn't work the way it's supposed to work, you want to make sure that the vendor is going to do something about it. But the reality is that AI is evolving rapidly, and I think it becomes difficult for a lot of vendors to provide robust warranties with respect to the AI tool. You're going to look at standard warranty obligations that you would put maybe in a SaaS agreement that are going to get pushback in an AI focused contract. You're going to want to have the AI vendor warrant that the tool complies with written documentation or performance standards that have been agreed upon. And I think for a lot of vendors, they're going to push back on that. Some vendors certainly won't, and you'll be able to get that kind of a concession from them. But at a minimum, you want to ensure that there is a contractual obligation that the AI tool is going to do what it is supposed to do, and have an understanding of if it doesn't perform as agreed upon or as expected or as warranted, that there is going to be some sort of remedy in the contract, that the vendor has an obligation to make it right. And you look at kind of the lay of the land here. A recent survey by a firm called Term Scout found that only 17% of AI vendors are willing to provide a performance warranty in their contract, at least in their standard form contract that they give to you. And that's versus 42% of cloud vendors. So there's a huge discrepancy in what warranty obligations typical cloud vendors are willing to step up to versus what an AI vendor is going to step up to. But the reality is you want to make sure that there's some sort of remediation. There's some sort of an obligation for the vendor to do something if that AI tool does not perform in the way that it is supposed to. Another critical issue in AI contracts is indemnification. And I think, indemnification for intellectual property infringement is something basic that needs to be in there. And that's true with any software-related agreement and most contracts in general. But, here with respect to AI, you're going to want to think about indemnification for algorithmic bias or algorithmic discrimination. You're going to want to consider an indemnification obligation from that vendor if, despite representations that the tool is going to be compliant with regulatory obligations or requirements, and it's not, that could be cause for an indemnity issue. You want to make sure that you've got data breaches covered with an indemnity obligation from that vendor. You want to think about indemnification obligations if there's a breach of confidentiality. All of those are important and something that you need to think about, including in your contract with an AI vendor. But you also need to remember that an indemnity is only as good as the financial condition of the vendor that's providing it. So in other words, if you've got a vendor with deep pockets, then the indemnity, I think, is going to work out well for you if you've ever got to utilize it. But if you're dealing with a small startup AI company that does not have a lot of resources, the indemnity obligation from them may not really mean very much, and may not be something that is going to provide you with a lot of substantive remedies in the event that you ever have to invoke it. One of the other things that AI vendors will do in the context of indemnity is have broad exceptions. So, just as an indemnity obligation is only as good as the financial condition of the vendor, it's only as good as the exceptions in the contract. An indemnity obligation that you're unable to utilize because of broad exceptions, which could include customer data, combination use, misuse, whatever that means. If the claim arises from outputs, from user inputs or user modifications and unauthorized use, it's unclear what a lot of those things mean. And if those all negate the vendor's indemnity obligation, it's really not going to be worth very much. I think the onus is on you to negotiate an agreement that is clear, that has reasonable carve-outs, And any kind of negation of that indemnity obligation is clear, is unambiguous, and is well defined. And I'm thinking of unauthorized use. What does that mean? You should make sure that that is well defined. Any kind of user modification, well, what's a modification? What if it's authorized by the vendor, but they're not doing it? Or if it's authorized by the vendor to have a third party do it, does that still negate the indemnity obligation? Or what if the claim that you're seeking indemnity for has nothing to do with the modification that was made? Should that negate the indemnity obligation? Probably not. So there's a whole bunch of nuanced considerations you've got to think about with both the indemnity obligation and the carve-outs to that indemnity obligation. One of the most important provisions in any software-related contract is really going to be limitation of liability, and it's no different in an AI contract. And I think you're going to want to have an understanding of what the cap on direct damages is. You're going to want to make sure that that cap is reasonable, that it is, either a subset of the amount you've paid under the contract in its entirety, or hopefully you're able to negotiate a cap that is at least the amount of fees paid due and owing under that agreement, or some sort of multiplier of that cap, depending on the nature of the AI functionality that you're utilizing. You want to make sure that any limitation of liability in a contract is mutual. You want to have an understanding of what the carve-outs are, and meaning, what is carved out from the cap, what is subjecting that vendor or you as a customer to unlimited liability. And you want to make sure that whatever you're agreeing to is reasonable, you understand the risk, and it's appropriate for the deal that you're about to get involved in. The other fundamental issues in an AI contract is going to deal with data security. You want to have an understanding, an answer to the threshold question: how is the vendor going to utilize your data, and what data are you going to provide to that AI vendor in the context of inputs to that AI tool? And I think in the context of AI, there needs to be a heavier focus in diligence on data security, what that vendor is able to do with the data, how they are going to protect that data, and the scope of their utilization of that data beyond anything than providing the service or the AI tool to you. In a recent survey of AI vendors with respect to utilization of data in connection with AI contracts, TermScout, the company that did the survey, found that 63% of SaaS contracts allow a vendor to use data beyond just providing the SaaS service to you. And that's in contrast to AI contracts, where 93% of AI contracts allow the vendor to utilize the customer data beyond just providing the service. So you can see there's a wide discrepancy in the way that these two different models are treating customer data. And again, you want to make sure you put some sort of fence around the utilization of this data by that vendor, and you're the one that is in control of how your data is being accessed and used. So in any AI contract, you want to make sure you've got the ability to test and validate the AI's performance. You want to make sure that you've got audit rights, that you can have access to that AI tool to test it, to make sure that it is meeting whatever regulatory compliance obligations that you have. You want to have some level of transparency into the algorithm, and to have an understanding of, is that AI tool actually performing in the way that it is supposed to? And if it isn't, that there is some remedy to that non-performance. And then finally, you want to make sure that you have the ability to get out of that contract. These contracts are similar to SaaS contracts, and sometimes the functionality is embedded in a SaaS contract. But if you've got an AI contract that runs for many years, a lot of times it's going to be difficult to get out of that contract before the term expires. You may be able to do it, but you want to have an understanding of what kind of cost outlay that's going to require. You want to be able to terminate that contract for cause, and ideally you should be able to get out of that contract with minimal financial obligation if that AI tool no longer serves you. These are just a few of the more substantive issues I think you need to pay attention to when you're negotiating and drafting AI contracts. If you have any questions about any of the issues I've discussed in this video, feel free to reach out to me at taflaw.com. I'd love to talk to you and get you pointed in the right direction.